On August 24, 2021, a Texas family court signed an order affecting the parent-child relationship between Taylor Shea and his child. But there was a critical problem. The case had already been dismissed 2 years earlier, in 2019. In virtual court proceedings held in 2025, attorney Mark Williamson filed a motion to set aside that order, arguing it was void from the very beginning. This case presents fundamental questions about court jurisdiction. Can a judge sign an order after a case has been dismissed? What happens when someone is never properly notified of legal proceedings affecting their parental rights? And what does it mean when a judgment is declared void? Today's footage begins in the courtroom of Judge Vonda Bailey, who must decide whether this 4-year-old order has any legal effect at all.
All right. We're on the record in cause number DF1803. Counsel, will you please announce for the record?
Your Honor, I'm Mark Williamson. I represent the movant today, Taylor Shea, the father of the child.
Thank you.
I'm Vicky Shea. I'm representing myself.
All right.
I'm McKenna Isbell, and I represent myself.
All right. Would all those who intend to testify, please raise your right hands and remove yourself off of mute. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
Yes, ma'am.
Thank you. You all may lower your hands. So we are here today on a motion to set aside a void judgment. I do have some exhibits that were pre-admitted, and we're going to go ahead and admit those now. So Miss Vicky Shea's exhibits A and B are admitted, and Mr. Taylor Shea's exhibits fathers F1, 2, 3, and 4 are admitted. All right, so we're going to take some testimony. It looks like an order in the suit affecting the parent-child relationship was entered by the court back on August the 24th of 2021. And there was a motion to set aside the judgment declaring that order void because at the time that the order was signed, the case had already been dismissed. Is that correct?
Well, the challenge today is to the personal jurisdiction over Mr. Shea and what the court just mentioned, which is a technicality, order of pleadings issue. So to be clear, there's the issue of can one amend their pleadings after their case has been dismissed, and would an amended pleading that's not properly before the court support any order? Our position is no. But secondly, the order should be declared void for lack of personal jurisdiction on my client due to lack of service of process, no waiver of citation, no court appearance, general appearance by my client, and the fact that he didn't sign the purported order that was entered back in 2021.
Okay.
Without those, it's our position that without jurisdiction, the court could not have entered that order.
Attorney Williamson has raised two distinct but related challenges to the 2021 order. First, he argues the order is void because the case had been dismissed before the order was signed. Second, he contends the court lacked personal jurisdiction over his client because Mr. Shea was never properly served with notice of the proceedings. Texas law is crystal clear on this issue. Under Section 102.009 of the Texas Family Code, parents are entitled to service of citation when any petition is filed in a suit affecting the parent-child relationship. This isn't merely a procedural formality. It's a constitutional requirement rooted in due process. In the landmark 1987 case of Peralta v. Heights Medical Center, the United States Supreme Court held that failure to provide notice to a party violates the most rudimentary demands of due process of law. The court emphasized that notice must be reasonably calculated, under the circumstances, to apprise interested parties of the pendency of the action. But there's an even more fundamental problem here. The Texas Supreme Court addressed this precise situation in re Dickinson, decided in 1998. That court held that any action taken by a trial court after it loses jurisdiction over a case is void. The opinion states explicitly, Judicial action taken after the expiration of the court's jurisdiction is a nullity. Here, Judge Bailey faces a straightforward timeline problem. Court records show the case was dismissed in 2019. 2 years later, in 2021, Ms. Shea filed an amended petition and a proposed order, but she did so in a case that no longer existed. When the previous judge signed that proposed order, the court had no active case before it. Under Dickinson, that order was void from the moment it was signed. Additionally, Mr. Shea's testimony will reveal he was never served with the amended petition, never waived his right to service, never appeared in court, and never signed the order despite a signature appearing on the document. Without proper service, the court could not establish personal jurisdiction over him. This goes to the heart of due process in American law. If courts could sign orders affecting parental rights years after cases are dismissed and without ever notifying the affected parent, the entire legal system would lose legitimacy. A void judgment is treated as a nullity. It has no legal effect whatsoever and can be challenged at any time.
Okay. Thank you, counsel. Let's see. Ms. Shea, did you want to go ahead and, because all you all are doing, you're giving argument of why the court should maintain this order.
It should stay maintained. He lived in my house in August the 2020 because we were taking him back and forth to work.
For the record, I need to object. Can I share my screen?
Yes, go ahead.
Your Honor, and while I'm doing that, I'd ask the court to take judicial notice of the contents of the file in this case.
Yes, the court takes judicial notice of all contents of the court's file. Counsel, what is your legal objection?
Goes beyond the scope of her pleadings. She filed a response to the petition on September the 2nd, 2020, wherein she said, I get this to work. She said, her answer says, I'm stating the lack of sufficient knowledge to admit or deny the allegations. As far as I know, we did not have court on August 19, 2021. So for her to now suggest that she does have personal knowledge, that goes beyond her pleadings. So that's our objection.
Sustain. Okay, Ms. Shea, let me say it to you like this. What Attorney Williamson is saying is that at the time that the court signed this order, the court lacked personal jurisdiction, meaning there was some sort of violation to his client's due process rights because he was not served with a copy of your petition or put on notice about coming to court or anything like that. So that's what you would have to defend of why the court should maintain the order. And the order that you have was signed after this court back in 2019 signed an order dismissing the case. So your order that you have from August 24, 2020 was signed subsequent to the court dismissing the case. So you would be trying to explain to the court why the court should maintain that particular order. Does that make sense?
Yes.
So go ahead.
Okay, the Taylor Shea was living in our home in 21 in August because we were taking him back and forth to work. Julie emailed us the paperwork under my email.
Same objection. I'm sorry, Your Honor. This goes beyond the scope of her pleadings. Her admission that she doesn't have personal knowledge sufficient enough to either admit or deny my client's allegations.
Sustain. So I guess the better way to say it, Ms. Shea, is what was going on at the time of the order is not the reason that we're here. We're here specifically on technical issues resulting in an order being signed when the court lacked jurisdiction to sign the order. So let me give you an example. I'm looking at the court's record, okay? This court back August 30th of 2019 signed an order dismissing this suit, okay?
Yes, that's back when in January 4th. Kim Cooks, I didn't know Kim Cooks dismissed it.
Okay.
This was all new to us.
Okay.
As of now.
Let me just walk you through it. She dismissed the case back then, okay?
Yes.
2 years after the case was dismissed, you filed an amended petition, and then you also filed a proposed order on the suit affecting the parent-child relationship. You remember doing that?
Yes.
After you filed that proposed order, the judge back then signed your proposed order after the case had already been dismissed. So at the time that the order that you filed was presented to the court, there was no live case pending at the time. You still follow me?
Yeah, but I didn't know that case got dismissed until here recently when I got these papers.
Judge Bailey is educating Ms. Shea about a critical distinction in law. Good faith and actual knowledge don't cure a jurisdictional defect. Ms. Shea genuinely didn't know the case had been dismissed, and that lack of knowledge is understandable. But the question isn't about what she knew, it's about what the court had the legal authority to do. Texas courts recognize two types of jurisdiction that must both be present for a court to act. Subject matter jurisdiction refers to the court's authority to hear a particular type of case. Personal jurisdiction refers to the court's authority over the specific parties. But there's a threshold requirement that comes before either of these. The case must actually exist. The Texas Supreme Court addressed this in Browning v. Plack, a 1985 case that continues to guide Texas law. The court held, a judgment is void only when it is apparent that the court rendering judgment had no jurisdiction of the parties or property, no jurisdiction of the subject matter, no jurisdiction to enter the particular judgment, or no capacity to act. When a case is dismissed, the trial court loses what's called plenary power, its general authority to act in that case. Under Texas Rule of Civil Procedure 329B, a trial court generally has only 30 days after judgment to modify or vacate its orders. After that window closes, the court can no longer act in the case. In this situation, the case was dismissed in 2019. The court's plenary power expired 30 days after that dismissal. When the 2021 order was signed, more than 2 years later, the court had no authority whatsoever to act. The filing of an amended petition doesn't resurrect a dismissed case. It would require filing an entirely new lawsuit. Judge Bailey is explaining this principle by asking Ms. Shea whether she has any case law to support keeping the order in place. This isn't meant to be harsh. It's helping her understand that legal authority, not good intentions, determines what courts can do. This principle protects everyone. If courts could sign orders years after cases end, parties would never have certainty about when litigation is truly final. The legal system depends on clearly defined boundaries of authority.
So essentially, what I would need to know from you, not based on what you didn't necessarily know, do you have any case law or anything to present to me today that would allow me to keep this order in place that was signed after the case had already been dismissed?
Like, what do you mean?
Do you have anything
Criminal?
No. So
No.
do you have something from a different court, like a court of appeals or something, where another case happened similar to this and the higher
No.
that they could maintain this particular order after it was signed once the case was dismissed? Do you have anything like that?
No, ma'am. Because like I said, we didn't know it was dismissed until I got these court papers when I
Okay.
got served.
Okay. Okay. Thank you so much. That answers a lot for me. Attorney Williamson?
For the record, may I call my client to testify briefly?
Yes.
All right. I'd like to call Taylor Shea.
Oh, could you stop sharing your screen, Attorney
I'm
Williamson?
sorry. Yes.
Okay, you're okay.
There we go. I'm about to start sharing it again if I have permission. Mr. Shea, tell the court your name, please.
My name is Taylor Shea.
And are you the father of the child that's the subject of this case?
Yes, sir.
All right. May I share my screen, Your Honor?
You may.
All right. Okay. Let me show you what is. Stop doing this. Beg your pardon, Your Honor. All right. Fathers 4 is your requested ruling, correct?
Yes.
You're asking the court to vacate the prior order, correct?
Yes.
All right. Fathers 1, that's a copy of the order that the judge signed. And I'll ask you, on the last page, did you sign that order?
No.
Is that your signature?
Yes. No.
I object to that one.
No, it's a different signature.
Hold on 1 second. I didn't hear any objection because everybody was speaking at the same time. Did someone make an objection?
I did, because that's not his signature.
Ms. Shea has objected to the signature evidence, claiming the signature shown on screen doesn't match other signatures she has. But she hasn't stated a proper legal objection. She's simply disagreeing with the evidence. Meanwhile, Attorney Williamson is laying the foundation for a handwriting expert's opinion. Under Texas Rule of Evidence 702, expert testimony is admissible when scientific, technical, or specialized knowledge will help the trier of fact understand the evidence. Handwriting examination is a well-recognized field of forensic document examination. The authentication of documents is governed by Texas Rule of Evidence 901, which requires only that the proponent produce evidence sufficient to support a finding that the item is what the proponent claims it is. This can be done through eyewitness testimony, expert opinion, or comparison by the fact finder. More importantly, forged signatures on legal documents can render those documents void. If Mr. Shea never signed the agreed order, then it was never actually an agreed order, and the court would have had even less authority to sign it without proper notice and hearing. Attorney Williamson is methodically building his record. He's showing that the signature on the 2021 order doesn't match Mr. Shea's current signature. He's also establishing that Mr. Shea never received service of process, never appeared in court, and never waived his right to service, all requirements under Texas Family Code Section 102.009. Judge Bailey properly overrules Ms. Shea's objection because it lacks a legal foundation. Ms. Shea would need to object on grounds such as relevance, hearsay, or foundation, not simply state her disagreement with what the document shows. The signature issue adds another layer to this case. Not only was the order signed after the case was dismissed, and not only was Mr. Shea never served, but his signature may have been forged on the document. This compounds the due process violation and strengthens the argument that the order is void.
Is that your current signature?
Yes, that is my current
And if
signature.
we compare that to Father's 1, those signatures are completely different, correct?
Yes.
All right. Were you served with process for this amended motion?
No.
Did you make any court appearances for the amended motion?
No.
Did you sign a waiver of citation regarding the amended motion?
No, sir.
Are you asking the court to vacate the prior order from 2021?
Yes, sir.
In addition, we hired a handwriting expert by the name of Kurt Baggett. Is that correct?
Yes, sir.
Kurt Baggett is qualified and certified by the American Institute of Applied Science and American Bureau of Document Examiners, correct?
Yes, sir.
And we asked him to compare the purported signature on this agreed order to your signature on Exhibit 2, and we asked for his opinion, right?
Yes, sir.
And his opinion was that the signature on the order was indeed forged, correct?
Yes, sir.
I'll pass the witness.
Attorney Williamson has just presented expert testimony that the signature on the 2021 order was forged. This is a certified handwriting examiner from the American Institute of Applied Science, lending significant credibility to the claim that Mr. Shea never actually signed the document. Forgery in legal documents can constitute fraud on the court, one of the most serious violations in the judicial system. Under Texas Penal Code Section 32.21, forgery occurs when a person forges a writing with intent to defraud or harm another. But beyond criminal implications, a forged signature on a court order raises fundamental questions about the order's validity. In Long v. Long, the Texas Court of Appeals held that when a party's signature on an agreed judgment is forged, the judgment may be set aside for fraud. The expert testimony here follows the requirements established in the 1993 Texas Supreme Court case E.I. DuPont de Nemours and Company versus Robinson. That case, which was later supplanted by Rule 702 of the Texas Rules of Evidence, established that expert testimony must be based on reliable foundations and reliable methodology. By presenting certified expert testimony, Attorney Williamson has created a strong record that Mr. Shea's signature was forged. This isn't merely Mr. Shea's word against someone else's, it's scientific analysis by a qualified expert comparing the question's signature to known exemplars of Mr. Shea's handwriting. This evidence compounds the jurisdictional problems already present. Even if the case hadn't been dismissed, even if Mr. Shea had been properly served, the order would still be problematic because it purports to be an agreed order that he never actually agreed to. Courts rely on the integrity of documents filed with them. When someone forges another person's signature on a legal document, they're not just committing a crime, they're undermining the entire judicial process. This case illustrates why procedural safeguards like service of process are so important. They prevent exactly this kind of problem.
Okay. Ms. Shea, this is your opportunity to ask any questions of Mr. Shea based on his testimony that he just gave.
Well, Mr. Shea, on the paper I got served, why is your signature different than the one that's on the screen? They're two different signatures.
It's not my signature.
The papers I got served in August has a different signature than the signature you have on that screen that's saying that's your original signature that is in green.
Can you pull the original?
This is Exhibit A that I got served with. That is
Your
your
Honor,
signature.
Objection, the document's not in evidence. That's not her Exhibit A or B.
No, it's your exhibit, but that's his signature on the papers that I got served with.
Your Honor, what she's asking my client is not an exhibit.
This is not your signature.
Okay, you all can move on to the next question, Ms. Shea. I sustain the objection.
And I did not. Why?
What was the question, Ms. Shea?
I don't have any right at the moment, Your Honor.
Okay. All right, Ms. Isbell, do you have any questions?
No, ma'am.
Okay. Attorney Williamson?
We rest.
Ms. Shea has finished her cross-examination, and Attorney Williamson has rested his case. Judge Bailey is now giving Ms. Shea an opportunity to present any witnesses or testimony in support of her position that the order should remain in effect. The burden of proof in a proceeding to set aside a void judgment is different from most civil cases. Normally, civil cases require proof by a preponderance of the evidence, meaning more likely than not. But when challenging a void judgment, the party attacking the judgment must demonstrate from the face of the record that the court lacked jurisdiction. However, once that showing is made, the burden shifts. As the Texas Supreme Court explained in MAPCO, Inc. versus Forrest in 1990, a judgment is void where it is apparent that the court rendering the judgment had no jurisdiction over the parties or the subject matter. The key word is apparent. If it's clear from the court's own records that jurisdiction was lacking, the judgment is void. The party defending the judgment then has the burden to show some legal authority for the court's action. Here, the court's records speak for themselves. The docket sheets show the case was dismissed in 2019. The records show no service of process on Mr. Shea for the amended petition. The signature issue, while compelling, is almost beside the point. The fundamental problem is that the court had no case before it when it signed the order. Ms. Shea bears the burden of showing legal authority for why the court could sign an order in a dismissed case. Her understandable knowledge about the dismissal doesn't provide that authority. As Judge Bailey explained, she would need to present case law or statutory authority permitting what happened here. This illustrates an important principle. Ignorance of legal procedures, while sympathetic, doesn't cure jurisdictional defects. The law must be applied consistently or it becomes meaningless. Ms. Shea's good faith doesn't change the fact that the 2021 order was signed without legal authority.
Ms. Shea, this is your opportunity to call any witnesses or give any testimony.
I didn't know we were allowed to have those today. I thought it was just us. I didn't know I was going to have witnesses.
Well, it's not required, but if you wanted to have witnesses, this would be your opportunity to do so.
Like a witness, like saying that, his signature was not forged, that it was actually his signature on the paper I put in for Exhibit A.
Well, not necessarily, because remember, this motion hearing is not about what took place at the hearing, if he signed it or anything like that. It's a matter of, was he notified of any amended petition? And according to his testimony, he's saying that he wasn't and he didn't sign anything.
Well, none of us were presented with the exhibits of compliances.
Okay. Is there anything further?
No.
Ms. Isbell,
Yes, ma'am.
Attorney Williamson, is there anything further?
No, Your Honor.
Okay. So the court is going to make a finding that at the time that the proposed order was signed, the court did not have jurisdiction to sign it, considering that there was no case open at the time. The case had already been dismissed by the court. So any order that's signed by a court, once a court has lost jurisdiction, is a void judgment. So the court is finding that the judgment is void, and I've signed the order to vacate the judgment.
May we get a copy of that?
Yes, I'm actually sending it out right now to the clerk and my coordinator will forward all of you a copy.
And now that order is void, it has no effect. I'd like just to admonish the parties to act accordingly, please.
Correct. There is, I don't even see an underlying order.
There's not.
Yeah. So there is not an underlying order. If you all decide at some point in the future that you would like to come back and put something in place, we will entertain it at that time. But as of right now, there is no order that exists between the parties.
Okay, so on the child in question,
Yes, ma'am.
is she able to stay here with me until we get this all settled?
That is because
Mr. Shea just
Yes, I would like to know that too.
Mr. Shea said he's leaving town next week. He's leaving for a week. He told my spouse that.
Okay, I muted you because I'm speaking and you're speaking over me. As of right now, without a court order, the only people that are allowed to have possession of the child are the parents. Without a court order, it is the parents. So this child needs to go back to her parents until a court order allows someone to do something different. If anyone is in possession of a child that they do not have a legal right to be in possession of, that is kidnapping.
Judge Bailey's ruling was clear and unequivocal. The 2021 order is void. Not voidable, void. This means it never had any legal effect from the moment it was signed. The court lacked jurisdiction when the order was entered because the case had been dismissed 2 years earlier. Judge Bailey ordered that the child must be returned to her parents immediately, as there is no valid court order granting custody rights to anyone else. Without a court order, possessing a child who has living parents with intact parental rights constitutes kidnapping under Texas law. This swift action protected both the father's rights and ensured compliance with the law. This case demonstrates 3 fundamental pillars of American jurisprudence that protect all of us. First, courts have limited authority. They cannot act beyond the boundaries the law sets for them. When a case is dismissed, the court's authority over that case ends. This prevents judges from exercising unchecked power and ensures predictability in the legal system. Second, due process is non-negotiable. Before the government, including courts, can take action affecting someone's fundamental rights, that person must receive notice and an opportunity to be heard. Texas Family Code Section 102.009 requires service of citation for exactly this reason. Parental rights are among the most fundamental rights we have, and they cannot be taken away in secret proceedings. Third, void judgments can be challenged at any time. Unlike most legal errors, which must be raised quickly or they're waived, a void judgment remains void forever. As Attorney Williamson noted, it's a nullity. It has no legal effect whatsoever. This provides a critical safeguard. Even years later, if someone discovers they were denied due process, they can seek justice. Cases like this one remind us that procedural protections aren't mere technicalities. They're the foundation that makes judicial decisions legitimate and enforceable. When a court follows proper procedures, providing notice, conducting hearings, acting within its jurisdiction, we can trust its decisions. When those procedures are bypassed, even well-intentioned orders must be set aside. This principle applies equally whether the case involves custody of a child, ownership of property, or any other legal matter. The law doesn't ask whether the underlying result was fair or what the parties knew or didn't know. It asks a simple question: did the court have authority to act? If not, its action is void. If you're ever served with court papers, take them seriously immediately. Don't assume something is wrong or will go away. And if you discover that a court entered an order against you without proper notice, consult an attorney right away. While void judgments can be challenged at any time, it's always better to protect your rights proactively rather than correct violations years later. Let us know if there's a case or courtroom interaction that you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so that we can help foster a more informed society.